When it's in half a day, the Committee on Health, Land, Justice, and Culture is now called to order. It is Wednesday, September 21st, 2022. The time is now 10:29. So we'll wait till 10:30. According to this, all right, actually it's 10:30. In compliance with open government law, notices for this public hearing were published in the Guam Daily Post on Wednesday, September 14th and Monday, September 19th, posted to the Guam Public Notice portal and live streamed in the Guam Legislature's YouTube channel. Notices were disseminated via email to all senators and all main media broadcasting outlets. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. The agenda item that will be heard today is on Bill number 314-36 COR, sponsored by Senator Mary Camacho Torres and co-sponsored by Vice Speaker Tina Rose Muña Barnes, Senators Christopher M. Dueñas, Jose Pedo Terlaje, Telena Cruz Nelson, James C. Moylan, V. Anthony Ada, Frank Blas Jr., Joe S. and Agustin, Amanda L. Shelton, and Sabina Flores Perez. It's an act to add a new Chapter 40B of Title VII of Guam Code Annotated relative to establishing a protection order for person who is a victim of a stalking conduct. I'd like to acknowledge my colleagues here, Senator Mary Torres, Senator Telotaitigui, and Vice Speaker Tina Rose Muña Barnes. So now to move on to the agenda item, Bill 314-36 COR, again sponsored by Mary Camacho Torres, co-sponsored by Tina Rose Muña Barnes, Senator Christopher M. Dueñas, Jose Pedo Terlaje, Telena Cruz Nelson, James C. Moylan, V. Anthony Ada, Frank Blas Jr., Joe S. and Agustin, Amanda L. Shelton, Sabina Flores Perez. It's an act to add a new Chapter 40B to Title VII of Guam Code Annotated relative to establishing a protection order for a person who is a victim of stalking conduct. I would like to invite the sponsor of the bill to provide introductory remarks. Senator Torres.
Thank you, Madam Chair. As you stated, Bill number 314-36 COR is an act to add a new Chapter 40B to Title VII of the Guam Code Annotated relative to establishing a protection order for a person who is a victim of stalking conduct. Madam Chair, Bill 314 recognizes that stalking victims require the same protection and judicial access as domestic violence and sexual assault victims. According to the Bureau of Justice Statistics, stalking impacts 3.4 million people in the United States every year, and of those stalked, almost 75% know their stalker. Stalking can also escalate to other crimes perpetrated against victims. A 2009 report indicated that over 35% of stalking victims or their loved ones were physically attacked by their stalker. 24% had property damage. Madam Chair, right now, there are few legal options for victims who have not had an intimate relationship with the individual stalking them. Some stalking cases are not prosecuted despite being reported. Further, while reporting is encouraged, victims who do not come forward are still entitled to protection from their stalker. Each of these cases necessitates civil remedies that require the stalker to keep away from his or her victim. To address this, Bill 314, similar to Bill 313, creates a separate protection order for a person who is a victim of stalking as defined in 9 GCA Section 19.70. It also contains similar remedies as a sexual offense protection order. Together, I believe these measures close a gap in our protection order process, one that excluded victims of sexual assault, stalking, and other heinous crimes. By making critical changes recommended by Guam's legal advocates, we not only provide victims protection from their offenders, but hopefully and more importantly, peace of mind. Thank you.
Ms. Masi, Senator Torres. For the record, invitations to provide feedback were sent to the following: the Guam Bar Association members, the Guam Coalition Against Sexual Violence and Family Violence and their partners, the Department of Public Health and Social Services, the Guam Police Department, Victims Advocates Reaching Out, VARO, and Office of Attorney General. We'd like to now invite Attorney Summerfleck, who's been kind enough to be here throughout this morning to provide testimony on Bill 314-36. Attorney Summerfleck, you're recognized.
Thank you very much. I'm going to get my statement right. My name is Daniel Summerfleck. I am the Executive Director of Guam Legal Services Disability Law Center. I look at this legislation and right away I would opine that you're increasing my workload substantially. This is a very common occurrence in our community. This is something that allows us to assist victims who are not subject to physical violence, but more of a psychological abuse as occurs in these situations. There are numerous situations where individuals are intentionally stalking. And they make their presence known. They drive by the house 4 or 5 times each day, honking their horns with the deliberate intention of intimidating or creating fear. At the same time, we have it with the increased use of electronic media, with the texting, with the other aspects. This provides me a means to provide protection to victims where there is not that physical abuse element. Oftentimes there are no threats. It is just 100 text messages a day. 100 text messages every day. I mean, I get a lot of emails, I get a lot of text messages. I don't know what I would do if I started receiving 100 text messages a day telling me, oh, I saw you were at Kmart at 4 o'clock today, and you were with so-and-so. I can't think of anything more intimidating or frightening than having some individual monitor every step a person may take throughout their day and then relaying that back to the individual. I can't think of anything greater that would cause myself fear than having a situation like this arise. But if there are no threats, there is very little that I can do to assist a victim. With this legislation, that ends. Probably the thing I fear most about this legislation is trying to track down where the perpetrator is unknown. That, to me, that 25% where the victim doesn't know who the perpetrator is, but starts receiving messages, starts receiving phone calls, starts getting emails from someone they don't know who's using, and this happens quite often, they're using multiple different phones. I mean, it's real easy to say, oh, that's from this number, I'm not answering it anymore. Much harder where they're using 3 or 4 different systems to communicate with them. So in looking at this legislation as it's offered, like the other legislation, it provides a remedy for people who are being intimidated, for lack of a better word to put to it. This legislation changes, again, creates a shift in our community. If you're going to send 100 text messages, I now have a remedy. Even if none of those text messages threaten the victim that they're going to beat them up, that they're going to harm them, because the way this is written would cause a reasonable person to feel intimidated, frightened, or threatened. And it doesn't, and then that's section A of stalking conduct, and then section C. even if the stalker did not intend to intimidate, frighten, or threaten. This again deals with that individual who comes to court and says, no, I wasn't trying to intimidate her by sending her 100 text messages. I was trying to romance her. For lack of a better way of saying it, it eliminates the bullshit. And it gets down to the issue. If you're sending, I shouldn't have said that on the record, should I have? Sorry. It eliminates that question. If you're sending 100 text messages, even 100 in a week, your purpose is to intimidate. Your purpose is to manipulate, and your purpose is to frighten and threaten. So looking at this, it again closes what has been a tremendous gap in our current system. As I previously mentioned, for a protective order, generally in the past, we're looking for the blood. Where's the violence? Where's the imminent threat of violence? This doesn't talk about violence. This talks about intimidation. This talks about threatening, and this talks about causing fear. And to me, this is just another step in providing protection. Now, why do I say this is probably going to cause a lot of work for me? Because this happens a lot. The biggest hurdle I see in this legislation is tracking down the perpetrators. And that, to me, I don't know how we remedy. But for those other 75% out there who know who the perpetrator is, who the perpetrator may have been someone they had a relationship with in the past, but it's never been violent, this provides a means to end this sort of what I would call abuse. So looking at this legislation, it again provides that level of protection to individuals from unwanted attention from someone they may know or not know, or may be simply an acquaintance. This is a clear means for someone to say, I don't want to hear from you, I don't want to have contact with you, I don't want to have anything to do with you, and I'm getting a court order to tell you to stop it. This happens more probably than anything else we come across as we work through protective orders. Even where there is violence, even when we have protective orders already in place, we continue to be battling with this stalking aspect of the abuse cycle. And I would opine to you that by putting this in place, we prevent further violence. This is an escalation. This is the first step of the escalation, or some means to continue to keep control over someone who you should have no control over. I get protective orders that say no communication. The most common violation is this: driving by the house, stalking, sending numerous text messages. This is behavior that if we move up the stream, we can prevent. So that I'm not seeking protective orders based upon violence, I'm seeking protective orders based upon stalking. This is something our community needs, and this is something, this legislation, as I see it, fills that need very well. Thank you very much.
Thank you so much, Attorney Summerfleck. So just a couple of comments about the review of the bill. So a preliminary review was issued by the Legislature's Legal Bureau with stylistic formatting recommendations thus far. The fiscal note states that although this bill seems administrative in nature, correspondence with the Judiciary of Guam indicates that a minuscule fiscal impact may be felt on operations. The Judiciary assumes that an additional clerk may be needed upon adoption and implementation of the bill. And based on the information provided by the Judiciary, the total estimated fiscal impact is cumulatively $55,564, which includes $28,595 for personnel and $21,969 for benefits, and $5,000 for equipment and supplies. So in the definitions of this Bill 314-36, it defines the stalking conduct to mean any course of conduct, whether physical, verbal, written, electronic, telephonic, via or by use of a computer, computer network, computer system, telephone network, data network, text message, instant message, or otherwise involving repeated continuing contacts, attempts to contact, monitoring, tracking, keeping under observation, or following of another that would cause a reasonable person to feel intimidated, frightened, or threatened, serves no lawful purpose, and the stalker knows or reasonably should know, threatens, frightens, or intimidates the person, even if the stalker did not intend to intimidate, frighten, or threaten the person. So this definition expands more distinctly the definition found in section 19.70 of chapter 19, 9 GCA. And so have you seen this language in another jurisdiction? And should this be harmonized with the definition in 9 GCA?
In my opinion, no. And my opinion is based upon what we're talking here is not just the crime of stalking, but provides us the ability to seek protective orders that may not meet the criminal definition. And I think that's very key. As I mentioned, this is kind of a start. It's either a start or perhaps an end, where they start with this course of conduct. For example, I've represented numerous victims where it was a domestic matter, and with no power, no violence again, but this pattern of practice to intimidate, to create fear by sending multiple messages to show control. I have control of you. I know where you are, and I'm going to let you know that I know where you are, and I'm going to send you a text message every time you move from one place to another. So to me, looking at this legislation, as I mentioned, it's going to create a wellstream of work, because this happens fairly regularly in our community. And now we have a means to seek a remedy without having to show physical violence or threat of physical violence. This form of intimidation is almost the worst form, because there is no way to defend yourself against it. There's no way to walk away from it. It's on your phone. It comes to you whether you want it or not. So I think that it's very important to look at this differently than criminal, to look at this as before the crime is committed and to prevent it. I would also make one comment on your fiscal notes. As a practitioner, I don't know, I don't speak for the court in any way, shape, or form, but one of the things that I've found that we depend on more than anything else in this process of obtaining protective orders is the fine work of the court marshals. They go out after 5 o'clock, they find these individuals, they serve process on them, and at that point, our orders are effective if they're violated. I would think with the additions that we're talking about of these 2 extra or 2 additional, I don't think they're extra at all, I think that we need them both, these 2 extra remedies, it's going to be more work for the marshals. And one group at the court I support probably more than anyone else is our court marshals. They go out to the most worst situations, they track people down, and they serve process. And to me, that is a vital aspect of this, and I would opine probably more vital than an extra clerk would be an extra marshal, because this is going to increase our caseloads, no question about it. But I would opine to you all that that role that those marshals serve is just as vital as any other aspect in this process, if not more vital, to get the documents to the respondent, to make sure that they've been served so that we can keep going forward. So I just throw that out because if you're looking at additional funding, I would earmark funding for the marshals. Whether, and again, I don't speak for the court at all, but to me, they are the unsung heroes at the court.
All right, thank you, Attorney Summerflex. So again, the question too for this bill is therapy. So I see the value of therapy in having more effective protection orders, and as well as with stalking. So do you see any conflict to require any kind of therapy for not just the victim, but also the respondent?
The potential contract for the perpetrator would be his statements he makes could be considered criminal in nature. And in order to be successful in a therapeutic relationship, you need to have that ability to discuss those aspects. I would be very hesitant were I a criminal lawyer to recommend my client to go to therapy, because who knows what they're going to disclose and what other crimes they may have committed that may come up during that therapeutic intervention. I think, and perhaps I come off old-fashioned, but I think the strongest remedy that we have in our bag of tricks is a court order. I don't know of anything stronger. I don't know of anything that causes more respect, and I don't know of anything more enforceable. I have taken numerous defendants in on contempt for violating court orders. It does help change the paradigm. It makes it very serious when the reality comes to them that they can serve 50 days up at DOC, and if the judge is creative, that 50 days can last an entire year or a half of a year. Because if the judge orders them to report every Friday at 5 or 6 o'clock and serve out 2 days every weekend until they serve their 50 days, I can't think of a more successful deterrent. And in the past, we've been successful in obtaining those kind of judgments of contempt, where individuals report to the prison at 6 o'clock and stay there till Sunday at 6 o'clock, and then do that every weekend until they serve out their 50 days. It's a very effective deterrent. I do identify the need of counseling, and I do think it's important, but at the same time, I'm not sure a court can order someone into counseling that would be effective if the perpetrator isn't going to freely disclose. So I understand your point, Senator, but I'm not sure we'd have much success with it.
Appreciate that response. So like Bill 313, this bill does not require a petitioner to show proof or have filed a police report. It does not require the court to need proof in order to issue a protection order. In these cases, how would the court determine that a protection order is warranted?
Of all the issues, oftentimes there's a lot more proof here because they send text messages, they send emails, but even as I brought up before with regard to sexual assault, again it becomes a question of who does the court believe? Who is credible when they present their testimony? And I guess one of the thoughts that I would come to, people don't come to my office because they want to. It's not, I want to file a protective order, yuck, yuck, yuck. It's more of, I have to. I don't know that many people come to my office to go through this process of obtaining a protective order unless it's actually needed. But I would opine to you again, a lot of the way the law works is based upon whom a judge determines is credible and whom a judge determines is not credible. And based upon what evidence or facts I as an attorney can put in front of them. If I can sum up in essence what the practice of law is, it's me as a lawyer presenting facts to a judge to apply to the law. So I can present the facts. It's up to the judge to determine whether the facts I presented are sufficient by the law to enter the order. And as I mentioned previously, and maybe in this aspect, perhaps more so than in others, we probably will be going to hearings more often where they won't agree as readily because they want to confess their love, they want to talk about how their soul and the other person's soul are mates, they want to, in some way, present this loving story about why they are pursuing the individual in this format. But it is the realities. And the realities is that this is the start point or the end point where they have no other options and they think they can get away with it, or at the beginning where they feel that they can harass in anonymity.
All right. Thank you, Attorney Summerfleck. Yes, I think it's important that we feel safe in our community, and I think these protection orders are vital to that, an important piece of that. And I do appreciate all your testimony today. So we are expecting another individual, Jane Flores, to come down. Maybe we can have questions for her when she comes in after her testimony. But at this time, I'd like to open the floor to Vice Speaker, if you have any questions of Attorney Summerfleck.
I don't have any questions, Madam Chair. Just want to extend my thank yous again to Attorney Summerfleck for literally taking the time to stay all morning and listen to all the bills and provide testimony in support of the efforts and working closely, like he said earlier in one of the bills, with the Attorney General's office. Again, I want to reiterate that in the past, culturally, sensitively, we probably didn't need any of this, but today it's much needed. And we try and do the preventative measures so that nothing escalates into the criminal format where we must file a complaint against somebody. So I do want to say thank you. I think your statements have been very supportive in the efforts of making sure that our residents are protected, making sure that the provisions that are here will secure that safety. And like you said earlier, sometimes people just want to be left alone, right? They don't want to be bothered, and sometimes people don't think that they're making a mistake or stalking and all that when they actually are, like you said, 100 emails or 100 texts. I mean.
Well, it's the bane of the new society, the electronic society, that we are accessible by so many means, and those means also provide an open door for individuals with improper purposes to misuse these new technologies.
Right. So thank you again, Attorney Summerfleck, and thank you, Madam Chair, for giving me the opportunity. I would also like to hear Ms. Jane Flores' testimony. So thank you, Madam Chair.
Thank you so much, Vice Speaker. So now I'd like to call upon Director of Bureau of Women's Affairs, Jane Flores, for her testimony. Thank you for being here.
Thank you. Thank you, Senator Perez and Senator Torres and Vice Speaker Tina Muña Barnes. I apologize for being late. I was at a Mayor's Council presentation and ran over here. But I want to testify this morning in support of all three of these bills, Bill 312, Bill 313, and Bill 314, because in my capacity as Bureau of Women's Affairs Director, I also serve as the Governor's Community Outreach Federal Programs Office Administrator, which handles our STOP and SASP Office of Violence Against Women grants that deal with helping victims of sexual assault and domestic violence. And I'm here to tell you that our numbers are rising and that the numbers are disturbing and that these bills close loopholes, and they are very greatly needed. With regard to 312, which in layman's terms, if I can so use those, and Mr. Summerfleck can correct me if I'm wrong here, but this would allow a victim of an accused domestic violence incident to stay in the home, even if the home is owned by the perpetrator or co-owned by the perpetrator, instead of kicking the victim and her children out, and then we have to find shelter for them, then this is really greatly needed. I really applaud this bill because they, kicking them out of their homes, kicking the children out of their homes is re-victimizing them. And, we all talk about not re-victimizing the victim. And so this really goes toward not re-victimizing these victims and helping them to have some semblance of normalcy in their lives, we can have locks changed and things like that. But what this does is at least alleviates some of their being uprooted and having to go to a shelter, and then we don't have enough shelter space. I also serve on the Guam Homeless Coalition, and we know that there is a great need for shelter space. There's a great need with Vero. I know Vero will submit testimony. They are constantly looking for places to shelter domestic violence victims. So this really helps this situation, I think. And Bill 313 closes a loophole for the protection orders of non-consensual sex acts if they are not eligible for a protection act under normal circumstances. Correct, Dan? Yes. And then also the protection order for stalking. So all three of these bills, I just want to say, are very much needed, and we are very much in support of them. And I do have some statistics for you. For 2021, GPD had 1,226 domestic violence incidents, and so we don't know how much of a percentage of those. I don't have stats on how many of the victims were removed from the home, but usually when a victim is removed from the home, there are children involved, and the children have to be removed. So it's not just one victim that we're talking about. It's a victim and 2 or 3 or 4 children. So this helps. I also have some sexual assault statistics from our brand new state implementation plan that is being reviewed by OVW right now. For domestic violence, the numbers have, in 2016 we reached a peak of 1,317. In 2017 we went down to 897, 2018 914, 2019 1,016, 2020 1,030, and then we jumped again to 1,226 incidents of domestic violence in 2021. So in the last 3 years, the numbers, in the last 4 years, I should say, the last 5 years, the numbers have consistently, since 2017, gone up. And in the last 3 years, they have been over 1,000 cases of domestic violence incidents in the past 3 years. So we're talking, this is a very needed bill, as I mentioned, with regard to trying to have some semblance of normalcy for these victims.
Thank you so much. Does that conclude your testimony?
Yes, and I will submit written testimony But I just wanted to come and show my support for these bills today. So,
Appreciate you coming down
Yeah.
and providing and support for these bills. And you bring up very disturbing statistics regarding domestic violence, but which I think requires a multi-pronged approach. There are many trying to get at the roots of the problems. That's always been my approach. Is like, what is the root of the problem? How do we address it? And I think oftentimes there's a lot of factors in play.
Definitely, drugs, alcohol abuse, those kinds of things. And that is maybe for another piece of legislation, but this one is to help the victims. I also have some, disturbing statistics about sexual assault cases reported in the last 5 years. And although the cases seem to have gone down a little bit, the problem with that is that the percentage of cases involving minors has gone up, and that is really disturbing. Since 2017, the percentage of minors involved in sexual assault cases it was 73% in 2017, 68% in 2018, 71% in 2019, 75% in 2020, and it went back down to 69% in 2021. But still, that's nearly 70% of the people who are sexually assaulted on this island are under the age of 18. And that to me is unacceptable. And so any bills, any legislation that we can help these victims, protect these victims, we fully support.
Okay, yeah, and I do know of families that have, sexual assaults in youth, and and some of them are youth on youth, right? The violence is between youth, between minors, and so these protection orders will apply to minors as well.
And there's always complications, with the families, and Senator Torres, maybe you can address this, but the courts can address those, or John, the courts could address if it's a family situation, but it should never be that the victim is removed from the situation. It should always be the perpetrator that is removed from the situation, because removing the victim from the situation, which is what used to have been done in the past, is, as I said again, just re-victimizing the victim, and we don't want to do that.
Okay, and the other thing you brought up, Director, was the homelessness, right? So I see, or I feel that that's a very vulnerable population, the
Absolutely.
women, the children, and basically, could be male too, of course.
Which is why Bill 312 is so important, because what it does is, if you have homeless victims, if you take the victim of a domestic violence situation out of her home just because the perpetrator owns the home, then you're making her and her children homeless again and adding to the homeless population, whereas, the onus or the punishment, so to speak, should be on the perpetrator, not the victim.
Yeah, but then in regards to the homeless population, so how are they going to get the information about protective orders? I mean, I guess is there plans to address
When we do, the Homeless Coalition does reach out, they do reach outs, I think, quarterly. And we have events where they come and they get a meal and they get, they find out. We had, last year, I think the Homeless Coalition did several vaccination stations. And so when we do these things, we give them the information, and they can always, we try to reach out to them, sporadically or periodically during reach out phases where we go to a place where we know the homeless are encamped and say, hey, if this is happening to you, then come here, we can help you.
Yeah, thank you for your responses. And yes, this is a very sensitive and heavy subject, and definitely something that we need to continue to work on. And we do appreciate these bills. I think these are really important measures. So thank you. So Senator Torres, if you have any questions at this time.
Thank you, Ms. Flores. I just wanted to ask you, as you mentioned the statistics on Guam, with regard to the preponderance of the sexual assault occurring with individuals under the age of 18, do you believe that there is that is a correlation with the hesitancy of people to report crimes or to come forward, adults, I mean? In other words, we oftentimes will rush to the defense of a child or try to bring justice for a minor, but do you believe that statistics are skewed because the reporting for minors is more likely to occur as opposed to the reporting by an adult victim?
I think there is some validity to that theory because sexual assault is the most underreported crime. That is statistically known, it is a fact. And young, especially children, especially now that we are back in school, their reporting is at a much higher rate because usually it's the teacher or the school nurse who notices something, and that's how that is reported. Or the child tells someone at school, who tells a counselor, or who tells a teacher. And because children are want to sometimes share things with their friends, whereas older women tend to keep it to themselves. So yes, that may be, and we know that these numbers are not the actual numbers, that there's actually a much higher rate because of that, because women are afraid to come forward.
And with that answer, it also ties in perhaps with what Attorney Summerfleck was discussing earlier about having this type of policy in place that will then become the impetus for people to become aware and to maybe take more action, but perhaps even the fact that there are remedies, civil remedies that are achievable, these might in themselves be, one person suggested a deterrent earlier in the panel, but I believe that it might actually incentivize people to come forward more, to file for protective orders, either from stalking or non-consensual sexual advances.
Exactly, if they know that there is something that they can do, if there's an avenue that I can reach out and get this order to keep this person from sexually assaulting me or stalking me, or because stalking can lead to sexual assault. I mean, or worse things. So
right, as statistically, national statistics have shown that over a third of all stalking incidences have resulted in physical attacks, and I think over 34% also for physical property damage. But with that, I bring that up because I believe that with these pieces of legislation, we're trying to close a gap that has been identified by the legal profession, this need for the protective orders. But I think what it also will do is bring the reporting and the awareness to a higher level where people feel that they don't need to be shamed, don't need to be afraid, and that in fact they can seek remedies for peace of mind and protection more than anything. So I'm hoping that at some point the underreporting will cease and that more people will come forward, and that's really where we need to begin as a community to heal.
And the Bureau of Women's Affairs is working on that. I have a meeting tomorrow with GDOE. We're talking about filling in the gaps, the Bureau filling in the gaps with presentations on period poverty and respect with regard to their curriculum that they have in the middle and high schools, with respect in the schools. In the elementary schools, they have the Lonnie Kate good touch, bad touch curriculum, and so, children are aware that way, but with more awareness, and we also have some ARP money. We are launching, early next year, we're going to be launching a PSA campaign with regard to sexual assault, domestic violence, teen pregnancy prevention, and human trafficking. And so we are hoping that if people are more aware of these situations, then they will be more want to report them. And as Cynthia Cabot always says from the Coalition Against Sexual Assault and Family Violence, higher numbers are not necessarily meaning that there's more sexual assault occurring. It just means more people are reporting. because we know there are a lot of sexual assaults that go underreported. So the higher numbers, you know, while we don't really want to see higher numbers, it's not necessarily a bad thing, because if more women report, there's more awareness, and men too, I should say that, or any gender reports a sexual assault, then there's more awareness, and with more awareness there can be more prevention and, you know, awareness of, you know, don't sexually assault.
Thank you, and I wish you Godspeed on your endeavors. Thank you.
Thank you.
Thank you, Senator Torres. Vice Speaker?
Thank you very much, Madam Chair. I don't have anything, just thank you guys for presenting today.
I
Truly
did-
appreciate it.
I did want to address, I had heard that Senator Titagwe was talking a little, she had mentioned something about, you know, false reporting, and I just wanted to say that the false reporting rate is extremely low. So, you know, we don't worry about that as much as we worry about getting the victims help and keeping the victims safe.
You know, Madam Chair, I want to tell Ms. Flores that earlier I said that back then, we didn't have to have legislation like this because of our culture and how we discipline and all that. But today, legislations and measures like this, in order to protect the victims, are truly needed today, because we have to bring the awareness out. We need to tell them that no is no, and we need to tell them that if you harass somebody, if you stalk somebody, then, you know, there's consequences that need to be paid. And too often, perpetrators think that they're not doing anything wrong. So I wholeheartedly support these measures with the good author from Santa Rita and Senator Torres, and thank her for that, because she, working closely with the Office of the Attorney General, and of course Attorney Summerfleck, who's been working this, I think he said over 3 decades, right? That's
a champion.
Not emphasize that.
He is a champion.
Yes, true champion, and it will help make a difference in our community, especially for our victims, and at least we know that we care, and we're trying to right the many wrongs that are out there today. So, si Diyos masi, Madam Chair.
Thank you so much, Vice Speaker. So I'd like to invite the prime sponsor for any closing statements.
Thank you. It's been a long morning, and I appreciate that everybody has been juggling their schedules to be here. Mr. Summerfleck, you've been a champion, staying the whole morning to address all bills in order as they were announced. But basically, these bills close a gap. They provide remedies for victims of abuse and sexual assault and stalking. That essentially, in a nutshell, is what 312, 313, and 314 do. And we feel that together these measures close a gap in our protection order process, and that had once excluded victims of sexual assault, stalking, and other heinous crimes. And I thank my co-sponsors. I think you've got the commitment of this legislature just by the mere fact that a great majority of us came on initially as co-sponsors of these measures. We are committed to assisting in any way towards addressing not only the livelihood of our victims so that they can overcome, but even going so far as to address the psychological abuses that for so long we have not addressed as a real factor in what plagues our victims on this island. So Siduos Maasi also, Madam Chair, for holding this hearing today, and I thank you all for being here. Siduos Maasi.
Thank you so much, Senator Torres, for championing a lot of these measures to help close the gap and to make sure that our community feels safe, even in our own homes, in light of the increasing, the almost epidemic proportions of abuse. And so, there being no additional individuals to present further testimony, this committee will consider Bill number 314-36 COR duly heard. The committee will remain open for the submission of additional written testimony for the next 10 working days following this hearing, which is October 4th. Testimony can be sent via email to Senator Terlaje, Guam, guam@gmail.com or hand-delivered to the Speaker's office at the Guam Congress Building. This public hearing is now adjourned. The time is now 11:20. Situas Masi, and have a great day.